Let me go on to my other guest. He's an attorney at law at the Caribbean Commercial Law Chambers. His name is Attorney Christopher Ford. And good morning to you, sir. How are you?
Hi, good morning, Mr.
You two have been here with us before, and we are so glad that you are. Take the time to be back. You're coming in the area because I want to talk about labor law, and that is part of your area of expertise. I want to deal specifically with the oilfield trade union workers threatening to follow through on the strike notice given to Petrotrin's management on Thursday gone.
Yes.
Many misunderstood the process of serving notice of a strike and thought, well, Friday morning there would be a strike. No, there was not one, because there is a process. Explain to our listeners how this process works, i.e. the union say we are marching down to Petrotrin and handing them a strike notice. What happens after that?
Okay, now, first of all, there's a dispute. So one of the parties, and according to the Act, of course, the Industrial Relations Act, one of the parties would report the dispute to the minister. Now, once the dispute is reported to the minister has 14 days in which to attempt some form of conciliation, to use her good officers to try to get the parties to meet to discuss the matter.
I see.
Now, if one of the parties decides, well, the party who reports the dispute decides that they want to engage in some form of strike action, or if it's the employer, lockout action, what they would have to do is that within that period, they would issue a notice to the minister and the other party indicating that it intends to engage in strike action. Okay? Now, when the 14-day period is up that the minister has to engage in some form of conciliation, then the union can engage in their strike action. I see. No, yes.
There's a cooling off period, or a period for offers to come backward and forward from both parties.
Sorry?
There's a cooling off period, as it were, an opportunity for folks to resubmit proposals to each other. You're trying to work this out.
Yes. After, like I said, after this dispute is reported to the minister, the minister can use its officers to encourage conciliation between the parties, bring them together, invite them to meet to try to resolve the matter.
The poker equivalent of I call.
Now, during that 14-day period, now they can issue their notice, and after the 14-day period is up, they can engage in their strike action.
I got you. So that's the reason that we have this cooling off period, and it is I want the arbitrary, because I thought it was arbitrary that the OWTU said we are going to tack on another 24 hours. They can do this?
Yes, they can. After the 14 days after the notice, the dispute is reported, they have up to 7 days to take strike action.
Oh, okay.
Yes, after which they can't.
I see.
Yeah.
I see. Got that. Now, there are two issues here in focus in the Petrotrin situation. One is the collective agreement for the period 2011 to 2014, and of course, the current one, which is 2015 to 2017. Now, those are two separate issues. What I found confusing here, and I think the Prime Minister alluded to it, and I will seek your clarification on it. How is one able to initiate negotiations of a new collective agreement when there is a previous unresolved one before the courts?
Well, because the collective agreement, the agreements relate to particular periods, right? So one might relate to 2011 to 2013. Now, during that period, unfortunately, the parties aren't able to come to an agreement as to what the terms should be. And with the inflection of time, of course, 2015 is upon us, and we haven't decided that period as yet. So we are in a new period. So we are to negotiate a new agreement, but the other one is still unresolved. So you find yourself in a situation where you're dealing with two.
Well, here is my confusion here, because outside of it being clumsy, it must be a management nightmare. Wow. Because you've got, first of all, I'm employing you. Here is the condition of your employee.
Yes.
But no, you know what? There are some parts of that that's we're not in agreement to. Let that wait and let us talk about you moving forward. I mean, are we not talking about what seems to be a prescription for
unfortunately, that's how it is, and that's why you have back pay. That's where the whole thing comes from.
Back pain, you said?
Back pain. Yes, that's where
many will say it is back pain.
You get money from a period that has been negotiated and now has not been settled, but passed.
So it's doable. You can,
in fact,
go ahead and do that.
It happens all the time.
The Prime Minister opined that it is most inconsistent. I concur with him on that.
It's unfortunate, but it's quite normal.
All right. Yeah. The attorney you're hearing is Attorney Christopher Ford. We're talking about the situation with the labor movement in Trinidad in general, specifically in focus is the OWTU. Is there a specific reason that the union identified 90 days for strike?
Yes.
And after those 90 days, make clear to our listeners, what does the law say?
Okay, what the law states is that once they initiate strike action, 3 months after continuing strike action, any party may make an application to the minister to send the matter to the industrial court. And once the matter is at the to refer the matter to the industrial court, I should say. And once the matter is at the industrial court, you cannot initiate any kind of strike action. So they know after the 3 months, the company can say, hey, write to the minister and say, well, we'd like to refer this matter, like you to refer this matter to the industrial court, please. And then the strike action has to end there. So strike action could typically go on only for 3 months.
3 months, and after 3 months, that's it.
And that's it, yes.
All right. I want to go back to the industrial court for a moment since you walk back there.
Yes.
The first case is sitting right there. What is the criteria for a dispute to reach the industrial court after? What is the criteria? Because I'm trying to. There's disagreement between both parties.
Yes.
Is that the only criteria?
Well, yeah, dispute is a disagreement. So
That's it.
Yes. So they have a dispute. So one party writes to the minister, indicates to the minister, well, we have this dispute. They set out very broadly what the dispute is, and then the process is initiated. And then the minister tries to engage in conciliation. Now, if during that 14-day period the minister decides that, well, there's no that parties aren't taking it seriously, then they could refer it to the industrial court. But otherwise, that is the procedure. Once it's a dispute, doesn't matter what it is. I mean, they can refer it.
Okay, so
yes.
during this 3-month period,
Yes.
can the industrial court order?
Yes.
Striking body to go back to work?
Yes. Now the act
What's the
provides
precedent for that? Tell me.
No, I've never seen it done, I should say, and I haven't been able to find one myself. But I know that if the minister considers that the national interest is threatened,
yes,
or affected, he or she in this case may apply to the court for an ex parte injunction restraining one of the parties from engaging or continuing.
Now, whose decision is this?
The minister.
The minister. If the minister finds it's inimical to the best interest of the country, then the minister can apply
national
to the court.
Indeed, for an ex parte injunction restraining the party from continuing with such action. And then the court will consider it and take whatever action it thinks is necessary.
And there's a reason I asked that, and I thank you for the clarification, because when folks talk in terms of stocking up because of what is the suspected inability of Petrotren to, over a long period, safeguard delivery of gas, you're running into that situation where the country comes to a stop. And in such a case is where you say the minister
certainly
will exercise.
We expect will take some action to resolve the matter. Yes.
The industrial court is part of the reason I ask you here, because there was statements, as you know, a couple of folks have been called before the industrial court because of some utterances that were not exactly welcomed by the court. And the reason I'm putting you here, not to put you in the middle of that revolution, but to ask you instead, generally, the performance of the industrial court, has that from your vantage worked neutrally at all, if you want to step into that area?
Well,
neutrally means, I always concede to something a politician told me one time. If both sides are unhappy, you're doing something right.
Well, you see, what I would say is this. The Industrial Relations Act, it's a very novel thing. It doesn't operate as the normal rules of court would operate. So the Industrial Relations Court, really, they aren't bound to precedent. Not normally. They aren't bound to the normal rules of court.
Right. Okay.
And there are certain sections in the Act that allows them to disregard other rules of law and make whatever decision they think is the best in the circumstances. What it leads to many times, I can tell you as a lawyer who practices in that area, it leads to a bit of uncertainty. You may have a situation, and we have faced a situation where an employer dismisses an employee for something that's legitimate. The court agrees that it's a legitimate dismissal, and yet still gives compensation. I'm not saying that happens all the time. It doesn't. But the court has the power to act on a case-by-case basis. Now, when something like that happens, I mean, the employer, it's confused, you know. He doesn't understand. He cannot reconcile it with what he understands the law to be. I did everything I ought to have done, and I did it correctly. Now, why am I being penalized?
No,
So,
probably isn't part of the consideration here drastic or using a hammer in the old sense, using a hammer to kill a fly. I mean, sometimes some actions can be taken and it's justified the action taken. However, en route to that action, a couple of things were stepped on.
No, I'm not even talking about. I mean, I agree. You might say sometimes the employer may act. The procedure may be procedurally flawed. How they dismiss the person.
Yes.
But no, I'm not talking about a situation like that. In a situation where it's procedurally flawed, it's not a proper dismissal. But I'm saying even where the employer follows the proper procedure, even where he finds that the employee actually did something wrong. Follow the proper procedure, dismiss the employee properly. The court agrees that it was a proper dismissal, and yet still they have that power, and they've done so, to still give some form of compensation. I mean, it leaves the employer unhappy. I mean, and you can understand why.
You can put a pin right there, because I would
Yes.
like you to have, if I remember, what led up to the charge against the parties.
Well, I'm not going so far.
The charge was you are entitled to a criticism, but you're not allowed to criticize the judges.
I wouldn't go so far. But like I said, it's a power that the law gives the court. So I wouldn't say necessarily that the court is acting incorrectly. They're just acting within the power that's granted.
That
to
is
them.
granted to them.
Yeah, so, but what I was saying is that you can understand why employers might be unhappy with that. Not to say that the court is acting unlawful in any way. It's simply exercising the power that they have.
One can understand why the employers will make that charge.
Well, I wouldn't make that charge, but yes.
All right. Attorney Christopher Ford, man, thank you so much. You cleared up a couple of areas on this process en route to a strike.
Yes.
What happens during a strike, and when can a strike be ended by industrial court order? That is very important to what we are discussing here. Just in parting, is there anything I neglected to inquire of you that you think can further bring elucidation on this issue?
No. I mean, at the end of the day, it's a tricky issue. You have a situation where the minister can take action, but then you're dealing with a state entity. So, I mean, the minister being a member of the government, you can say the action by the union is being taken against the government. You can say so, being a state.
All right.
Industrial
industrial
minister
relations.
taking action in this case, it's a tricky one. So
Industrial relations reform. We'll make sure and nominate you for one of the parties in that.
what I would say, Mr. Bishop, before I go, is that I think we need some reform, as you just said. The Industrial Relations Act speaks very broadly to what is harsh and oppressive, what is good industrial relations practice. But I think we need some sort of code whereby employees and employers can look through and they can read without always having to run to a lawyer for advice. We need a comprehensive code that sets out what is right and what is proper in the workplace.
It is called a two-pager. It applies to just about every bureaucracy in the world. Oh, God have mercy. Does it ever? No, I concur with that 1,000%. You can start with the banks as the beginning. I'm sorry, I didn't say that.
But yes.
Attorney Christopher
that's the only thing I'd
Ford.
like to add.
Thank you so much, man. I truly appreciate it. Good to see you this morning. You have yourself a wonderful year.
Thank you, man.
Thank you so much.